the falsity of these statements that have been made previously. I will, in my proffer, just outline exactly what those statements are and what I wish to be allowed to solicit from this witness. On June 18th, 2014, this witness testified to the magistrate court, and that oral testimony at 5 minutes and 19 seconds into that oral testimony said Justin and his wife at this time are being questioned. They are not showing much emotion regarding their child's passing away. I'd like to ask this witness about that statement that he made and his knowledge as to the truth or veracity of that based on his own investigation, both talking to witnesses on the scene as well as what he may have observed at the headquarters. That is search warrant 14 SW0596, and I'll provide for the record a copy of that search warrant, and the copy of that oral testimony actually is already in the record from our motions hearings that we've had, and I'd ask the court to just incorporate those that are previously issued in the record so we don't have a duplication of that. Secondly, on June 18th, warrant 14 SW0597, the statement made in the affidavit of that warrant was that during an interview with Justin, he stated that he recently researched through the internet child deaths inside vehicles and what temperature it needs for that to occur. He also, in his oral testimony for that warrant, indicated he said this is one of his biggest fears, referring to Mr. Harris, and that is why he recently researched this. Again, these are statements made by this detective under oath to the magistrate, for which, again, not offered for the truth of the matter because, as he's indicated, he didn't even watch the interview. Where he got that information, if he got it from somewhere else, I don't know because I've not been able to even ask him about that. That's 14 SW0597. That initial, the affidavit information stating that during the interview with Justin, he stated he recently researched through the internet child deaths inside vehicles and so forth. That was used for 10 search warrants, 10 times testifying under oath to those statements, which we know at this point, based on the evidence, are completely false, and that was offered to the magistrate in the attempt to obtain and ultimately to successfully obtain search warrant. On June 18th, the fourth warrant, this involving the iPhone 5, 14 SW0599, at 3 minutes and 24 seconds into the oral testimony, this witness stated he also made statements regarding that he had researched how long it takes someone to die inside a vehicle, what's the temperature it needs to be. And with his iPhone capabilities, he has internet access, possibly see if had researched that information on the phone as well. Again, personal statements made by this witness to the magistrate under oath. And we'll provide the copy of that warrant, or excuse me, we've incorporated that warrant in that oral testimony. On June 19th, for warrant 14 SW0605, at 4 minutes and 24 seconds into that oral testimony, this witness stated, during Mr. Harris' interview, somehow it came up that this was his biggest fear, and he had done research on how hot it needs to be and how long it takes for animals or small children to pass away in vehicles in this manner, which seemed kind of odd. He said he had just researched that. Again, that is not borne out by the actual evidence in the case. It is not true. It is not offered for the truth of that statement. It is offered to show, for all of these, trying to make very clear the defense, which we have a right under the Constitution of the State of Georgia and the United States to put up a defense which challenges the investigation, the credibility of these officers, and to impeach the credibility of witnesses who have testified in this manner. Not seeking to impeach this officer's credibility, seeking to impeach the other officers who have testified. And what's very important to note at the outset, and I should have done this from the very beginning, my understanding is that as we have attempted to bring out this information previously from Detective Stoddard, the state objected, had a conference with the court, and the statement at that time was that he was not the proper person to get this information to because he was not the declarant, thus it was hearsay. Makes some sense. So we have gone to ourselves because the state refused to call the second-in-command detective to testify in this matter. We have brought the declarant here at our expense to testify to satisfy the objection the state had. Now they object and say, no, we can't do that because it's hearsay somehow. We respectfully disagree on the legal grounds for that objection, as well as just the practical grounds of this is the way to get this information out, is from the person who actually said it. And that's what Detective Murphy is here for. Going further into 14 SW 0606, also on June 19th, the continued affidavit testimony, I will not repeat it. We've been through that already. That's also true for 14 SW 0607, 14 SW 0608. In that warrant, which was obtained June 19th at 1 minute 17 seconds into the oral testimony, this witness stated, the purpose of the search warrant is to examine the documentation and the search engines inside the device related to some comments that were made by Justin Harris and his wife regarding researching child deaths in vehicles and any research related to that. 14 SW 0609, also on June 19th at 59 seconds into that oral testimony. This witness stated the purpose will be for related to statements that Mr. Harris and Ms. Harris made regarding doing internet searches regarding child deaths in vehicles and how long it takes in the heat of the vehicle and any other searches related to this incident that could be obtained in the Apple MacBook. Further on June 19th, 14 SW 0610, at 1 minute into that oral testimony, this witness stated, search the Apple iPad for any research Mr. Harris or Mrs. Harris had done on it regarding in-car vehicle deaths and how hot it needs to get and any kind of research related to the incident. 14 SW 0611, at 1 minute 5 seconds into that oral testimony, this witness stated, and also related to statements he made about searching the internet regarding in-car child deaths and how long it takes the temperatures, and also to check the device to see if he had did some kind of internet search on that, on this iPhone device, or any other search engines related to this. On June 24th, search warrant 14 SW 0633, there was changed language as to the warrants that we just talked about, the 10 warrants that were taken out with the affidavit, which had stated improper information, not improper, false information. And that language has changed to say this. According to Harris, he recently viewed a television show concerning child deaths in cars. Harris also stated that he researched the issue of deaths in cars on the internet. Also, that warrant added the language, when the seats were inspected, the straps for the seat were set out on the lowest level for a small child. And we have been able to ask about that observation. I think ultimately the state objected to our asking the question about him testifying to that, but at least we do have the information about the mistake as to that information. At 4:08, in the oral testimony for that warrant, 14 SW 0633, the magistrate judge asked, or stated, you've already sworn to what's contained in the application. Let me ask you to reaffirm what's contained in the application. What you have now testified to has all been the truth. The magistrate court, seeing the solemnity and the importance of telling the truth and being under oath, and this witness testified, answered yes. 14 SW 0634, also obtained on June 24th, and this is a series of warrants which have been testified to as far as repeating this process, which is interesting in itself, but not the purpose of this proffer. During that oral testimony, again, this witness referred to looking for searches of in-car deaths. That same affidavit language that we told the court they've added or revised the language goes on through 14 SW 0635, 14 SW 0636, 14 SW 0637, 14 SW 0638, 14 SW 0639, 14 SW 0640. And as regards that particular warrant, this again was obtained on June 24th. This is for the residents. When asked about by the magistrate judge regarding whether Mr. Harrison made some statements about purchasing bulbs, and this detective informed that Mr. Harrison never made the statement about going to the vehicle, but it was discovered from a surveillance video. And he stated in a quote, after speaking with some of the, he went out to lunch with 2 other employees. He spoke with them regarding it. They told us he got the light bulbs and returned to the vehicle. When asked to clarify whether or not Mr. Harris had never told them about going back to the vehicle during lunch, response was no, he never disclosed to us that he returned to the vehicle during lunch. The importance of that is we would ask and want to have this witness testify that there was no testimony given regarding the other individual who in fact had also forgotten about this trip to Home Depot for the bulbs. As to 14 SW 0641, this was obtained on June 27, 2014. Again, the affidavit language which talks about or claims under oath that Harris also stated that he researched the issue of deaths in cars on the internet, and then talks about his failing to tell the investigators about the trip to Home Depot and going back to the car. 14 SW 0633, this was obtained on June 27th. On that occasion, this witness testified to the magistrate that in fact, quote, he briefed at 2:40 in that oral testimony, he briefly attempted CPR on the deceased child. Again, this would help to impeach other testimony which claims that Ms. Harris was not providing CPR to his deceased child. 14 SW 0654, also on June 27th, we have the same affidavit language, and that is recounted in the oral testimony. 14 SW 0655, again, we have the affidavit language that I've spoken of earlier. Basically, for the first 10 warrants, they had the same language that we've objected to and want to be able to bring out to this witness. They then took 18 warrants based on revised language, which also had misstatements of the truth in them. That continues to 14 SW 0656, 14 SW 0657, 14 SW 0658, 14 SW 0659, 14 SW 0660. Again, all these are being obtained on June the 27th of 2014. Then on August the 14th of 2014, this witness again appeared before the magistrate using the same revised affidavit language and said at 3 minutes and 33 seconds, when the seat was inspected, the straps, they were set too small for the child that was in them. And then he goes on to talk about the lunchtime incident. At lunchtime, Harris then returns to the vehicle with a bag of light bulbs, opens the door and places them in the vehicle. The child is in the vehicle at that time. He does not see the child. This witness testified under oath that Mr. Harris, after they've looked at the surveillance video, he tells the magistrate, Mr. Harris did not see the child. We believe that that statement should be able to be provided to these ladies and gentlemen of the jury that this witness has testified to under oath to a magistrate. At 7:09 of that same oral testimony, the judge asked what they were searching for in trying to search the Lenovo ThinkPad. This witness testified for any type of research on hot car deaths, in-car deaths. And when the judge asked him, well, you're telling me that Harris had during his CAP interview said, he also said he had researched deaths in cars, but he didn't say when? This witness' response was correct. 14 SW 0844, obtained on August 19th, 2014. At this point in time, they removed the language regarding the straps on the seats, presumably because they realized it was wrong, but then added this language. During the investigation, Harris's other work computer, which was issued to him around March 2014, was examined. It goes on to say it was discovered that he went to a Reddit site and visited articles on living child free. He also watched a YouTube video titled, How Hot Does It Get in a Hot Car? That completes the matters of the warrants that were obtained by this witness and the testimony we seek to get from him. Let me state very clearly, as best as I can, we are traveling under Mr. Harris's constitutional right to a fair trial. That includes the right to thorough and sifting cross-examination of a state's witness. It also allows us a thorough direct examination of a witness that we have to call because the state objected to us getting this information out through what we contend was the proper witness to begin with, but nonetheless, to make sure it's very clear, we called the actual declarant of these statements to testify to the truth of those matters. This is not hearsay. It is not being offered to prove the truth of the matter asserted, as we've said before. I will cite to the court a couple of cases very quickly. U.S. versus Jimenez. This is an 11th Court of Appeals decision in 584 Federal 3rd 1280, the 2009 case. And interesting in that case, what you have is you have some, I believe this is the one that involves a detective who is trying to providing testimony about what a suspect had told him. And the question was whether or not this is a defendant appealing the state's use of this sort of hearsay against him in violation of his Confrontation Clause rights. The court made very clearly it was not hearsay. It was not admitted to prove the truth of the matter asserted, and it cites Federal Rule 801, the Georgia counterpart, of course, being 24.8-801. Rather, it was received, we believe, for the limited purpose of showing only that the statement was uttered by Jiskif, J-I-S-K-L-I-F, that's the suspect, to Wharton, W-H-A-R-T-O-N, who's the detective. As we have already explained, during the cross-examination of Wharton, defense counsel questioned the detective at length about the details of the successive interviews with the defendant and Wharton's decision not to obtain a written and signed confession from Jimenez. The cross-examination was designed to impeach Wharton's credibility and suggest that Wharton was lying about the circumstances surrounding the interviews about Jimenez's confession. That was deemed to be not a violation of the defendant's own confrontation rights. I think we're good to remind the court, or to refresh ourselves, and the state, frankly more so, the state does not have that right. The defendant has constitutional rights. This court is in place in order to uphold those, and we believe the state's attempt to try to convince this court that somehow this is hearsay and this should be precluded, the truth of these matters should be precluded from getting to these ladies and gentlemen simply because they don't want it in. They didn't like it before because they claimed we didn't have the person who said them. We brought that person here and they don't like it now. We have a right to put up a defense for Mr. Ross Harris. We've been very clear from the beginning. Part of that defense is attacking the credibility of this investigation. What we've seen and what the evidence has borne out is, in fact, this investigation has been fraught with misinformation, misleading, misstatements, and outright lies. We're trying to put in front of these ladies and gentlemen of the jury to understand the full context of that, where some of this was coming from. I don't know that Mr. Murphy or Detective Murphy is the one who's responsible for starting those. Unfortunately, these ladies and gentlemen don't even have the benefit of knowing how far that went to the point of taking testimony and giving testimony under oath in violation of the truth. We simply want the truth to be out to these ladies and gentlemen. We have a right to attack the credibility of the state's investigation. We have the right to impeach the prior witnesses who've testified in this case. Testimony has been regarding where this information came from, and frankly, we question some of those explanations that have been given to us. I'll also offer to the court, again, I'm reading from Paul Millich, Handbook on Georgia Evidence. An out-of-court statement is non-hearsay when offered to prove that it was false. Zinneman v. State, 261, Georgia Appeal, 2003. Also, U.S. v. Costa, 31 F. 3rd, 1073, 11th Circuit, 1994 case. The statement is offered because it's known to be false and its falsity supports the proponent's case is not hearsay. I believe the court understands our position. I know this is a difficult and trying matter. I know we're late into it. But Mr. Harris's opportunity to have a fair trial pervades everything else that we look at. The state's position is founded on a hearsay objection, which clearly is not founded in the law. The state's dislike for this testimony is not founded in any legal proposition, that can be offered to the court. Frankly, I think the state is putting the court in a very difficult position by suggesting, well, you can't go into it to the lead detective because he's not specifically the one who said it. And then we bring the person who said it, well, you can't go into that because he may have gotten it from somebody else who may very well be the lead detective. We don't know because we can't even ask that question. So I'd ask the court to reconsider its precluding us going into the defense or Mr. Harris. The truth should not be considered some sort of weighty object that keeps us from moving forward. The truth should be what we're giving to these ladies and gentlemen. That's what we're trying to do. The state is obstructing that. We've asked the court to, despite their unwillingness to bring the truth out through this detective in their own case, allow us to be able to bring forth his own statements made under oath, given previously, so that the jury can weigh it all. In so doing, we believe as far as his defense, it allows us to attack the credibility and frankly to help illuminate and show what we've been saying from day one, which is the state totally disregarded actual evidence right in front of them. They disregarded it, they misstated it, they misled it. They created a narrative that now has them in this position where we are today. And we believe that's a right the defendant has, and we'd ask the court to allow us to exercise his constitutional rights.
I find it interesting that the defense would make these accusations of continued falsehoods and things like that when in the beginning of the trial of this case they started with their own opening statement, putting in false UTC codes and making false statements and assertions that we've now proved to be false during the trial of this case. Yet they want to come in here and try to slander the state and try to talk about all of the misstatements that they made when up on the slides they actually showed an opening. They clearly were showing stuff that was just false. Now I'd like to hope that that's a mere mistake on their part and not an intentional falsehood, but it doesn't do anyone any good to hurl accusations such as that. It doesn't answer the legal questions that are before the court, and that's what we need to focus on. The argument that we refuse to call the second investigator, it is extremely rare that we would call the second investigator in a case like this for the very reason that we've shown to the court, which is all he has to offer is hearsay. I mean, basically the way it works is he interviews a bunch of people. If we call those people and they lie on the stand, you can call this witness and you can say, okay, well, look, we want to put in a prior inconsistent statement, which is exactly what they cited to in the Millich argument to the court. But you can't just bring in a witness who doesn't have firsthand knowledge about things and expect them to be able to regurgitate what they did, especially when it's been the subject of prior litigation that the court has already ruled on. We've litigated this extensively. There was an argument about credibility at the motion to suppress. You've ruled on that. We've addressed those issues before. Anything having to do with the search warrants is simply irrelevant in terms of what's being presented to the jury at this point. With arguably one exception, I'll point out to the court I didn't object to. Detective Murphy said something in his search warrant affidavit about something he had firsthand knowledge about, and he was mistaken. And that involved the car seat. And you'll note that I didn't object to what he had told the magistrate court about, whether it was on the lowest versus the second to the lowest. Why? Because that witness has firsthand knowledge about that. That's different. That's maybe arguably impeaching this witness about a substantive fact that he has personal knowledge about. And the state didn't object to that. But for all of these other things, when you go through them one by one, statements at the outset that the defendant and wife are being questioned now. He's not a part of that interview. He doesn't have firsthand knowledge of what's being said to him. All of that information that's being relayed to the magistrate is coming from an additional source. It would be hearsay. It's not properly admissible before this jury because it's other people passing on that information. Recently researched child deaths in a car. Well, we're talking about semantics here, quite frankly, we can talk about that in closing argument, but all of that is information he's getting from another source. That would be hearsay, and you've already ruled on those litigated matters. Statements about how long it would take to die in a car, it's hearsay, it's semantics, it was litigated before. That's part of the motion to suppress. You've made specific findings about that. It's not relevant before this jury. Biggest fear on how long it would take for animals or small children to die in a car. Well, first of all, he doesn't have firsthand knowledge on that. He wasn't a participant in any of the interviews. That's been litigated. It's semantics, quite frankly, and it would be hearsay because he was not a part of those. I could go through the entire list. I don't think it's necessary to do that, but clearly all the information that this detective was passing on to the magistrate was information that he was getting from other people who in turn were getting it from third persons themselves. And under the authority we provided to the court, that's absolutely impermissible. There's no constitutional right to present hearsay evidence. There's no constitutional right to present irrelevant evidence. And there's no constitutional right to a thorough and sifting direct examination of a detective. When you cite Jimenez, for example, we're talking about a Rule 801 as party opponent. That's a completely different rule than we would be dealing with here. We stand by the authority that's been presented to the court. You've made a proper ruling regarding that, Judge. There's arguably one area where this detective had some personal knowledge. We've allowed them to explore that one area. Other than that, it would be hearsay and it would be irrelevant as to your prior findings and prior rulings regarding the motion to suppress.
Just very briefly. The state wants to argue semantics or say it's semantics. We're simply asking for truth. We want the truth to be able to come out. No matter how you slice it, this is not out of court declarant statements offered for the truth of the matter asserted therein. That's what hearsay is. This is not that. As regards to, I'm not even going to address the opening issue, but the defense right to put forth its defense in accordance with the applicable rules of law. That's what we're all operating under. The applicable rules of law say that we should at least be able to ask this detective, when did you testify to this? Did you have personal information about it? And if not, why did you testify to that? It explains his, even if it were hearsay, it would explain his conduct, but it's not. If it came from someone else who maybe in fact the other witness who's already testified, then it's offered to impeach that witness who's testified, again, in error. We ask the court to allow it.
All right. I stand by my prior ruling. A record has been made by the defense as to its proffer, and we can proceed with the jury in the courtroom for cross-examination.
It's all right for the jury, please. Please be seated.
Cross-examination.
Detective Murphy, because we had a little bit of a break, I only got a few questions for you. I was really able to pare them down. So your role in this case was extremely limited because you were not the lead detective, agreed?
Yes.
Okay. You were the secondary detective in this case, which is not uncommon to have a secondary in a case of this magnitude. Is that true?
Correct.
Your role as a second detective as opposed to a lead detective is more of a support role, correct?
Yes, sir.
Okay. And if the detective needs something for you to go do, then the lead detective delegates that to you. You in turn can either do it yourself or delegate it to someone else. Is that correct?
Yes.
And of course, whatever you're asked to do, you document that and make it part of your police report so that it can be turned over to the lead detective and ultimately the state and defense, correct?
Yes.
And for example, in this case, you didn't interview the defendant. We saw that video. You weren't a part of his actual interview in this case.
No, I was not.
Okay. Similarly, you didn't interview Leanna Harris. That was not something that you accomplished.
No, I did not.
Okay. Sometimes the detective who's the lead in the case might ask you to go pick something up like medical records or go execute a search warrant or something like that, so that they can continue on as their role in lead detective, correct?
Yes.
And that's the support role that you took up in this case.
Yes, it is.
There's a whole list of individuals that the defense asked you about, individuals that you spoke with. For many of those interviews, Detective Stoddard was actually there present with you, correct?
Yes.
Okay. And as you're making these interviews, when you're able, do you try to record them?
Yes.
Okay. And of course, the recordings are made part of your case file, correct?
Yes, they are.
As part of the recording process, do you also take down that information of those individuals so that if we need to call them during a trial, we can?
Yes, I do.
Okay. And you make that part of your case file so that either the state or the defense could call any of those people on the list?
Yes.
And I'm going to object to comments made by the prosecutor. I'll take that up at the proper time.
And did you make a list of those individuals, and was that made part of your case file?
Yes, I would attach their information to my supplemental reports.
Okay. All right. Thank you, Detective.
Your guidance for determining what to look at and what to consider and who to talk to, all those decisions were being made from Detective Stoddard?
As far as investigation, he had asked me to reach to basically, as far as the witnesses on scene, the uniform officers had a list of people that were witnesses, and that was handed over to me, and I was asked to contact those people and interview them.
And you would turn all that over to Detective Stoddard so he could decide what to do?
I would interview them, take notes, record it, if it was available, and then complete a supplemental report detailing what, or summarizing what the interview was.
And you would give those to whom?
Be turned over to Detective Stoddard in the case.
Thank you.
No further questions?
All right, you can step out. Council votes.
Brian?
All right, ladies and gentlemen, I've conferred with council, and we have accomplished what is available to be accomplished for the day. Now, just to let you know, organizing and keeping witnesses going all the time is a major event, and it's just really hard to know how long this is going to take. And with the state's witnesses at the beginning, right after the hurricane, now with the defense witnesses, it's hard to know how many people to have here, and we have to bring people out of Atlanta or some other place and house them. And if we went too long and we had other witnesses sitting around in hotels, or in the case of the state situation, there were no hotels, it's all very complicated. So I think under all the circumstances, everyone has done a real, what's the word for it, soldier on, good job in keeping us going, compliment both sides. That said, we have done what we can do today, and we're gonna, it is Friday after all, we sure have worked hard, and so we're gonna stop right now for you all. So, we're in recess, close your notebooks, leave them in the jury room, keep an open mind, and don't discuss the matter with each other, nor with anyone else. Remember your responsibility with your family, your friends, the folks you're gonna watch the football game with on Saturday, whichever side you're for. Because I think down here it's it's not like at home, but there's a whole lot of issues going on down here as to who you're rooting for. But whoever you're gonna enjoy being with and enjoy your time with,